When my grandfather passed away, he left me our family's 2,400-acre lakefront ranch on the shores of Flathead Lake, Montana. At the heart of the property stood a handcrafted cedar cabin that had belonged to our family for nearly 70 years. Along with the deed came every original key, survey, and ownership record. The cabin wasn't just another vacation home. It held decades of family memories, fishing trips, holiday gatherings, and handwritten journals carefully preserved inside. My plan was simple: restore it while protecting the property for future generations. Only one neighboring community bordered a small section of my ranch. Their HOA maintained nearby vacation homes, but had no recorded ownership inside my family's property. For years, both sides had peacefully respected the boundary fence. One afternoon, I noticed unfamiliar vehicles parked near my private dock. Curious, I walked over and politely introduced myself. That's when I first met HOA President Karen Mitchell. Karen smiled before making an unexpected request. She explained that her teenage son loved the cabin and believed it would make the perfect place for him after graduation. She suggested I consider giving it to the family. I thanked Karen for sharing her thoughts, but politely explained that the cabin was private family property and not available. I wish your son the best, while making it clear the ownership wasn't open for discussion. The conversation ended respectfully, or so I thought. Over the following week, several neighbors mentioned hearing rumors that I planned to sell the cabin soon. I had never said any such thing. To avoid misunderstandings, I posted a simple sign at the driveway entrance reading "Private Family Property." I also reviewed every survey and boundary marker around the estate. Everything remained exactly where it belonged. A few days later, Karen returned carrying a folder filled with HOA paperwork. She claimed the neighborhood should have priority access to the cabin because it benefited the local community. I calmly asked if any recorded agreement supported that claim. When Karen couldn't produce any ownership documents, I offered to review anything officially recorded with the county. She declined the offer and left, promising the HOA would handle the situation. I simply documented the conversation. The following week, I received a certified letter from the HOA requesting that I transfer the cabin to their association. The proposal described it as a community asset, despite the recorded deed showing otherwise. My attorney immediately began reviewing the paperwork. My attorney searched county records for any easement, covenant, or transfer involving the cabin. Every certified document confirmed continuous ownership by my family. Nothing connected the cabin to the HOA. To remove all doubt, I hired a licensed surveying company to verify every property line. Their GPS equipment confirmed the cabin stood well inside my ranch boundaries. The measurements matched the original surveys perfectly. The survey report included detailed maps, photographs, and certified measurements. My attorney sent copies to the HOA, inviting them to review the findings together. We hoped clear evidence will resolve the disagreement peacefully. Instead of accepting the survey, Karen rejected its conclusions and insisted the cabin should still become available for her son's future. My attorney quietly closed the file and prepared for the next legal step. From that moment, every discussion would rely on documented facts. A few days later, Karen filed a formal complaint with the county, claiming the cabin had become a community landmark that should be managed by the HOA. My attorney calmly requested every document supporting her claim. We were confident the official records would tell the real story. During discovery, the HOA produced meeting minutes and neighborhood newsletters, but no deed, easement, or ownership agreement connecting the cabin to the association. Every certified county record still listed my family as the sole owner. The evidence remained one-sided. The county recorder personally certified that no transfer involving the cabin had ever been filed. Property taxes have been paid continuously by my family for decades. Every official agency reported identical ownership information. At the same time, I learned that the HOA headquarters accessed its parking lot through a narrow strip of my privately owned land. Previous owners had simply allowed the association to cross it without a written easement. My attorney advised documenting everything before making changes. A new GPS survey confirmed the access strip belonged entirely to my ranch. There was no recorded easement granting permanent access across it. The discovery explained why my attorney suddenly smiled. Rather than acting immediately, I sent the HOA a professional letter offering to negotiate a permanent legal easement. It included fair maintenance terms and reasonable liability protections. My goal was cooperation, not conflict. Karen rejected the proposal without suggesting any alternative. She insisted the HOA already possessed permanent rights and refused further discussion. My attorney advised me that I could now enforce my property rights lawfully. Licensed contractors began installing a strong wooden privacy fence along the exact property line identified by the survey. Every post followed the official boundary markers. Construction remained entirely on my land. By the end of the second day, the HOA office remained standing exactly where it always had, but its usual shortcut across my property was gone. Access now depended on reaching a legal agreement. The fence protected my land without touching theirs. Karen rushed to the property, demanding the fence be removed immediately. I calmly handed her another copy of the certified survey and my earlier easement proposal. The offer had never expired. The sheriff's office received another complaint and sent a deputy to inspect the property. After reviewing the survey and boundary markers, the deputy confirmed the fence appeared to be entirely on private land. He encouraged both sides to continue resolving the dispute through civil channels. The court hearing focused on two separate questions: ownership of the cabin and access across my land. Independent surveyors, county officials, and title experts all testified using official records. Every witness emphasized documented facts rather than assumptions. The judge confirmed that the cabin belonged exclusively to my family under recorded deed. The court also recognized my ownership.